Right, so yes, indeed, it's been a very intense conversation over the past couple of weeks about the vacant seat saga and the matters arising as a result of the judgment of the Supreme Court of Ghana. Supreme Court, in a 5-2 majority, says, well, yes, Apenyo Markin's processes filed have been upheld because they believe strongly from the processes that were adduced before them that indeed Speaker of Parliament did not have jurisdiction to declare those seats vacant, and the interpretation of the law therefore makes it possible for those 4 seats not to be declared as such, and so the MPs can return to the House. And tonight we're having a conversation with Justice William Atuguba, a man who is known clearly for his stay at the bench, doing amazing works there. And for 21 years, he was at the bench until his retirement in 2018. And so it's a very good opportune time for us to have that conversation with him on this. So, Justice William Atuguba, so thank you so much again for having us. So, you have believed strongly that the Supreme Court lacked jurisdiction on this matter. And you even talked about the fact that it's not just about jurisdiction, but processes also.
Yeah.
But when you look at the judgment, the 5 justices who believe that indeed the Supreme Court had jurisdiction, they cite Article 2 as well as 130 of the Constitution to buttress their point. You say that's not convincing?
Well, it's not. When you consider those provisions in relation to Article 97, I think, specifically deals with vacancy of parliamentary seats. It isn't that the Supreme Court had no jurisdiction at all, but the type of jurisdiction they had in this matter would be a jurisdiction of reference. Articles 2 and 130 give very broad jurisdiction, very generalized in terms of interpretation and enforcement in relation to acts and omissions and other laws which may be passed and are felt to be inconsistent with the Constitution. These are very broad powers. Now, that's what the Supreme Court dwelt on. He said that this matter concerned interpretation of Article 97, and so the Speaker had no power and all that, so they can interpret and so. But as I said at the beginning, the abortive beginning of our conversation, what was the essence of the matter in Parliament there? It was about the vacancy of the seats, whether the Speaker ruled that they were not vacant or they were vacant. It was all an issue about the vacancy of the seats. And 97 deals with that specifically. Are we saying that in doing so the Constitution was unaware of Articles 2 and 130? They were aware. But they specifically excised that particular matter and lodged it in the High Court. Just like fundamental human rights. You can't go to the Supreme Court about fundamental human rights. Although later on it was said that when there's class interests, class rights, you can go there. I disagree with that, but anyway, it has come to stay. But if it's individual rights, even if interpretation is involved and you feel your right is breached, you go to the High Court. And if the right you are asserting, the particular provision you are relying on is difficult of understanding, that's what calls for interpretation. Then The High Court, if it's convinced that the matter really is difficult of comprehension, of easy comprehension, they are constitutionally bound to refer that question of interpretation to the Supreme Court. The Supreme Court doesn't take over the case, it's only to do that interpretation,
Right.
after which it sends back its interpretation to the High Court. And then the High Court determines the matter. You see, determines the case that has been brought before it. Supreme Court has no right to take over and decide that case. You see. Oh yes.
So were you surprised to have seen that 5-2 majority, even though Justice Lovelace Johnson as well as Justice Amadou Tanko were with your position that the Supreme Court did not have jurisdiction on this particular matter? Were you surprised to see that 5-2 majority decision?
Well, when you say surprised, yes and no, because it was for the court to decide. And, well, after going through, they thought that that was the correct way. But having been there for this time, I don't think, I just cannot agree that they were right. Because, as I've explained, Articles 2 and 130 are general provisions. This 97 is very specific about vacancy of parliamentary seats.
And that resides with the High Court.
With the High Court, yeah, that's what I'm saying. With the High Court. It's so specific, you know. And that's why parliamentary results are normally contested in the High Court. Nobody loses an election and then goes to challenge the result in the Supreme Court. So it's in the High Court. The same Article 97. So why is it that that 97 governs parliamentary elections and they always go there? And then the same 97, which also gives vacancy of parliamentary seats to the High Court. You say I can't go there. I can't get it.
You can't.
I can't.
Well, some have also expressed concern.
Yeah.
Looking at the judgment that was issued and the fact that, well, we did not necessarily hear from the speaker's side because even at the last hearing before the judgment was delivered the next day, his lawyers were not in court. And some say, well, perhaps we shouldn't have seen a judgment while we've not heard from the speakers. Yes.
Oh, for that one, I don't think. So, is the court to be held up for somebody who has a right to come and is not coming? I don't, you know when he will come? So they should be waiting there until he chooses to come. The court's duty is to give him his right, his chance to be heard. That is what they are required to do. But if he decides to, not to come, the court definitely has to proceed. So you have two parties. How do you tell the other to wait until, well, if he doesn't come at all?
Justice must still go on.
I don't know. I don't think the speaker has explained why neither he nor the other. But I don't want to go much into that. You know, there was argument that he couldn't engage a lawyer without going through procurement, and the procurement will have to locate counsel from Attorney General's office for him. I mean, anyway.
That argument.
Huh?
The Attorney General made that argument.
Yeah, interesting. When we were there, a similar matter arose. It was a case of Megache as Attorney General. And there, the Attorney General's position was at variance with one of the parties, which was a state body. And the Attorney General was saying that they were not entitled to go in for private counsel because they are a state body and he's the Attorney General. But at our time, we said, no, that would be absurd. Your interest is at variance with his, and you want to be his counsel. No. In such a situation, they are free to. Yes, it's the same thing here.
Yes.
I heard an argument that the speaker has no interest. Hey, it's a party, but he has no interest. Huh? It's a proper party, but he has no interest.
It's not possible. Interesting.
And when the orders are given, who is liable for their non-performance? Will be the speaker. So how is he not interested? And these are some of the things.
There are so many questions about it, and one of the conversations I've also had after this judgment came out is the fact that, well, when you look at the writ that Apenyomakin basically filed, 97.1G, quite specific. But when you look at the judgment, you're seeing an H added to it, and some have argued that the Supreme Court had no business adding H to the 97.1G, that the interpretation that Apenyomakin sought at the courts. Do they have a case?
Well. I don't think that matter is. I would go by that. You see, the Constitution is fundamental. See, law is so involved. People, before they talk, they have to make sure they consider so many things. If it is a relevant provision to the matter, the parties overlook it. The Constitution is fundamental, even if it's not an ordinary statute. It is a deep-seated principle of the common law that a court, when asked to give a decision contrary to a statute, must itself raise the point. You are bound by the act. How do you deliberately, because parties, so, but you have to give them the chance to address that matter, to be heard on it fully argued. Yeah, that is it. Especially this constitution is very fundamental. Can't use procedural rules to suffocate the fundamental law. No. So I won't go with that. No.
And similar cases were also raised about, well, Apenyomakin never mentioned the NDC's parliamentary candidates from Memphis Central. But then, in the judgment, we saw that also feature in there.
It appears that originally, when he filed his, he was confining himself to the MPP.
Yes.
But I think when he filed his statement of claim, statement of case, I think he alluded to it. But even that one is neither here nor there. The issue is the same, whether there are 10 vacancies or 1 vacancy. It's the same issue, same law involved. Even if you were not mentioned, but that this type of action is an action in rem. It's not an action in personam. It's about the status of the person. Once the status is pronounced, it binds everybody, the whole world. So anyway, so that too is just a technicality.
At the judgment, and the fact that, well, Supreme Court has settled 5-2 majority. Well, what are the lighter implications on Parliament?
On Parliament? Well, I think they know best, but looking at it legally, it's an interesting scenario because all it does is to say that those 4 MPs are still entitled to be in Parliament. That's what it says. Incidentally, at the end of it, I think they only did the interpretation. They didn't even order the Speaker to do anything. I think it was the original one when there was a state action allowed others. This one, they simply interpreted. So that's a declaratory judgment. Declaratory judgment is not a, I mean, to enforce it, you got to take further processes. There's nothing to execute, you know. At best, I mean, the only thing is the Speaker has now to allow those MPs to come. If he's not, you have to go back and take further processes to compel to comply. As I said, it's a declaratory judgment.
And that's what people have. In fact, I've had conversation with some MPs from the NDC side.
Yes.
And they've told me that, well, this thing, Speaker will not do anything about it. In fact, yes, the Supreme Court has given its judgment, but Speaker can decide whether or not to actually abide by it.
Well, not quite. No. I mean, he's bound by it, but it's the enforceability aspect. You see, if I think initially, that's why sometimes when you're the journalist, I want to see the real legal text before I can feel confident. But I've so far been proceeding on the briefings you give. This is what happened. Hey, but if it turns out otherwise. Anyway, but of course, any law-abiding Speaker, whether it's declaratory or whatnot, you go by the law. But what does it mean? I mean, he's just to summon his Parliament. He can't compel any MP to come. He presides over the Parliament as convened, yes. And then he goes by the numerical strength. If they have up to 1/3, there's quorum, but they can't take decisions. And as for the MPs, you can't compel them to come. It is when they fail to attend Parliament for 15, I think, consecutive sittings without any reason or permission, they can be expelled. But that is it. That's the sanction there. I don't see any power of a Speaker to say, hey, come bring so and so.
Right.
It's not like that.
Right.
So, and it appears that when this action was mounted, those 4 MPs themselves were not, they considered themselves as outside Parliament. They knew that the consequence of the actions they took led to the vacation of their seats. I think one of them came out that he was not surprised that he saw this coming.
Memphis Central MP.
What's his name?
Kojo something. Yeah. The NDC MP. He said he was not worried about it because he knew that this is what would have happened. And so he's going independent anyways.
Yeah. And even so far, I don't recall any of those affected MPs attempting to come to Parliament.
We've only seen Cynthia Mamle Morrison, but not in the chamber.
Yeah.
She mostly around job 600 with the MPP caucus.
Yes. Still being an MPP person?
She says she's still an MPP MP, but then for the elections, she's running as an independent candidate. And so she's still aligning with the NPP MPs in Parliament.
I see.
Yes. Holding press conferences with them and everything on these issues.
I see.
Yes.
I thought they were running after and she was also standing her grounds. But I take the facts from you.
Yeah, she says she's still an MPP MP.
Okay, MP.
But then for the December elections, she's contesting as an independent candidate.
Yeah, okay.
And that's where people say that this decision or this judgment from the court rather will open the floodgates.
Yeah.
Because as it stands now, people can just get elected on any party's ticket and then can decide to go run as independent candidates in an election that really is ahead of them. And so it would weaken the parliamentary system.
Yeah, definitely. Definitely. Besides this ambivalent stance of going independent as far as the elections are concerned and then still being with the party, I mean, I don't know how healthy, how wholesome that is. It's a question of trust. It's a trust issue. Allegiance. You know, that's what the provision is about. So that people don't poach other parties' members and deplete their numbers and so forth. So, I mean, it's an awkward situation. You are out there campaigning against the party's candidate, strongly trying to defeat the party's candidate.
But you're a member of the party.
Yeah, a member of the party.
In parliament.
While in parliament. So, in the field, you are outside the party. In parliament, you are with the party. I can't think far. I think somebody has been using that expression.
Yes.
Sometimes I hear it being said. I mean, let's take a very banal example. As I have a wife, and the wife tells me that, oh, in 10 days' time, she will cease to be my wife. And she starts packing her things. She's going to marry a different person. She starts packing her things there. But so long as she has not finished packing, she's my wife.
Yes.
And then I say, hey, but how can this marriage be?
Living in the same house with you?
Well, not quite, because, okay, living in the same house, let's take it that way.
Yes.
Living in the same house, maybe just coming to sleep, it's not even quite, but when we are outside, she won't associate with me. I call her, she won't mind me. But she comes to sleep and say, oh, in 10 days time. But meanwhile, she's moving her things to the other person's house. I mean, you think that that's still my wife? Yes.
So for you, the Supreme Court's interpretation of 97.G as it stands now, it's problematic?
Oh, yes. Because, as I said, I don't know how that was imported into the... Of course, construction can take any form, and so they did some deep thinking and reasoning about it. But then, look at 97. A member of parliament shall vacate his seat in parliament. A whole lot of things. Then it is F. If he resigns, hold on, G. If he leaves the party of which he was a member at the time of his election to parliament to join another party. So this, let's stop here. Let's say right now, some are contesting on a different party's ticket. I say they haven't joined that party. It's only their members who can contest on their ticket. So definitely you are a member. And their constitution is such that the moment even you move out, they'll just push you out. You are no longer. So, I mean, fully. So, this provision is, have you joined another party or not? I don't see more words to it than that. And if you have gone to join another party, That is it. You know, the purpose for which you have gone to do it is not. It's not within the purview of this probation. You know, and so it's the same train of thought that will govern somebody going independent.
Yes.
Same train of thought.
And then the independent candidates also join the political party now.
Yes. You see, and the the Supreme Court, I agree with them that those provisions must have a uniform effect. The effect of joining a party or going independent.
Yes.
I intended to have the same effect. I agree with that. But to say that the purpose for which you have joined is what determines whether you have your seat is vacated or not, I find it difficult to reconcile with the simple words here. Let's go again. And if you see a difficulty, you can help me. Yeah. If he leaves the party of which he was a member at the time of the election to Parliament to join another party, or seeks to remain in Parliament as an independent member, or if he was elected a member of Parliament as an independent candidate and joins a political party. These are the circumstances specified. It's movement,
Yes.
left or right. That's all this is about. And that movement, from the intendment of the provision, means that once that movement occurs, you are thereby diminishing your original party's numerical strength, one way or the other.
Yes.
And that's the mischief sought to be cured.
Right.
Now, this futuristic interpretation, I mean, you see, you have the letter of the law and the spirit.
Yes.
The two must go together, you see. Which of these two warrants what the Supreme Court has said? Is it the spirit or the letter? We've read the letter. Where is the futuristic aspect of it? I can see it. And, you know, so that should end it.
So in your opinion, once a member of parliament, per your understanding of Article 97(1)(g), it triggers a process to move away from the party in which he was elected, clearly the seat becomes vacant.
Sure. Because, see, as I said, it's a trust issue.
Right.
I've said on some other platforms, and I casually read this provision. First, I thought, why somebody is contesting a future this thing, but, you know, when you, and that's the trouble I have with human beings. We are not direct and honest.
Right.
That's where we have problems. That's where we have problems. If we were, everybody is interested in what is right and straight, most of these problems won't occur. You know? Look, what do the parties themselves do? Which party do you know that its member has left to contest as independent? What does their own constitution say?
Automatic.
Automatic. So what is all this pretense about, oh, somebody has gone? I mean, I don't like pretense. That's my life.
Right.
Because it causes problems. Let's be straight and honest. And things will go well.
Right.
Yeah.
Right.
I talked about the letter of the provision. The spirit is about the trust, like the speaker said. It's about the trust. It's a trust issue. And I think that's why the parties too, as long as you move out they don't consider you are an enemy.
Right.
That's it. The trust is lost. So how can the trust be there outside Parliament, and then it's expected to be inside Parliament? What's the crux of your membership of Parliament? Is it Abontini membership or intra parliamentary house membership? I mean, that's not.
Let's just go straight to the point. Let's not be pretending.
Yes.
Okay.
And that's why I always confess, I have problems with politicians.
You believe they pretend so much? They're not honest?
Well, what is your view? You are all. No, some of them are. I've mentioned Apia Kubi.
Yes.
I don't know him, never seen him. Mentioned him. I've mentioned Ayikwe Otu.
Yes.
I've mentioned Gloria Kufu. A number of them. Even Damboche is just because he's too deep in it. But that man, I think he's a God-fearing person, but he's too connected. But if a principal matter comes, I don't think he will. You look at Andy's side, Zaneto Rawlings. Oh, I think she's my model politician.
Oh, Senator.
Zaneto. I don't know her personally. It was when I was sitting on her case. That time she was a small little girl. We called her case. She appeared in the gallery. That was all. Never seen her. But from social media, her political posturing is very positive. She's not in for the usual kind of. No. It's a direct and, very proactive, objective management. I have not seen any tinge of dirty politics in her career, from what I see on social media about it. And that's why I like you, the judge, because you are my source of information. Social media, There's another man, I've never seen him, but I think he's, yes, Okudzeto Ablakwa.
Someone Okudzeto Ablakwa.
Yes.
Not MP.
Yeah, that's a guy who, yes, he's straight.
Right.
There's another guy, I think he's called Murtala Mohammed.
Yes.
From Tamale or so.
Yes.
Yeah, from social media and what he says about himself. I think these are people who are, such people, they are politicians, but I don't fear them. But the typical ones, see your light white as it is bright, and they say it's deep black, and you should endorse that. To be fine with them, my friend. I've told you, justice here, omnibus.
Omnibus, justice.
I can't apply justice to that situation. That's why I find problems.
With the
Yes.
Justice, thank you so much for
That's all right.
engaging us, indulging us this evening. We are really grateful.
No, that's
and I'm
fine.
sure that we'll definitely come around again.
Yeah.
Then we can have conversation. I mean, getting to the elections, we'll look at other matters
Yes.
as well.
Yes.
Thank you so much for.
No, you don't thank me. We are all working in the interests of the people of Ghana. I want their best interest to be served. That's all I'm concerned about. And I see that it's not, it's staggering. I feel I have to also, when I'm called upon to help to put things on course.
Definitely.
Yeah, so I rather thank you for giving me this opportunity to play a little part.
And I think when I come back, I'll talk more about politicians, because I like your perspective about honesty and then and how politicians should carry themselves. And then we'll look at or how they've fared in the last couple of years and what they should be looking at. But next time I come, we'll be looking at that.
In 2020, when I launched a book in Cape Coast, and I emphasized two things. That One, Ghana is a state, but it's not a nation. It's a state. It's put together constitutionally with the boundaries stated and all that, and the constitution in place. But whether we are operating as a state is another matter. We are not. That's why ethnicity is still so strong.
Yeah.
How is it consistent with nation building? How? We don't see our oneness. You know? So I said, no, we have to. I said, we ought to call a national debate or forum to consider whether we are a nation or state.
Interesting.
Oh, yes.
I've not thought about it like that.
Oh, yeah, you can see.
Yeah.
And it's showing in the politics.
True.
Huh? Then also, I said the idea of politics has to be redefined.
Right.
Because, I mean, the way it's played means that it's not well conceived. We say politics is a dirty game.
Yeah. And to be a strong politician, you have to play by some really dirty rules.
Yeah. Why must it be so? Is that what the Constitution has put in place? But as you say,
we'll come back for that conversation. Thank you so much. Thank you so much.